Aging Insight, empowering you through the aging process.
All right, so today's topic is, and maybe the reason why it's sold out today, we had about 36 people that we had to turn away because we ran out of space, and that's after being overcrowded last time and getting more space. So now I don't know if it's the topic or if it's just my pretty face or what the deal is. But I figure I'm gonna blame it on the topic. When it comes to wills, that's pretty popular. People want to know about it. And so today's topic is doing it yourself, how to create your own will. I will preface this by saying, if you do it yourself, you will do it wrong. All right? Let's say that I was a surgeon, and I'm the best surgeon in the whole world at pulling out an inflamed appendix. And I got up here and I told you step by step everything you need to know in order to cut out an appendix. If you went home and figured you'd give it a shot, you're gonna mess it up. All right? And when I say that, I'll just give you, I had just yesterday, I spent all day in El Dorado, Arkansas visiting with folks over there. And I was talking to a family. They were coming in to get some estate planning done. And part of the motivation for them coming in was it was a husband and wife. And his mother had gone and done some planning, had it done professionally. But then at some point in time, as life went on, she decided, well, she didn't want all that mess. So she threw all that in the trash and did some stuff herself. They got it all, after her death, they got it all resolved, and it only took 3 years and somewhere in the $30,000 to $40,000 range to get it all cleaned up. So it worked eventually. All right, so I'll just preface all this. This is, it's kind of like watching those videos of somebody doing something stupid, and they start out by saying, don't try this at home. All right, so, all right. But one way or the other, I'm going to tell you, because despite all of that, everything I've just said, it was a couple of y'all going to do it yourself anyway. So hopefully what I can do today is limit how bad you're going to mess it up. All right? I'm just trying to minimize the damage here. All right, so if you're going to make a will, before you ever put pen to paper, you're going to have a couple of things. The first thing is you've got to actually intend to make a will. This, in legal terms, they call this testamentary intent. As an example, there was a guy in New Boston, and he wanted to get a will done, and so he wrote a letter to his attorney. And in the letter, he said, "Dear lawyer, I would like you to prepare a will for me, and in this will, I would like you to leave everything to my spouse, and if she's already deceased, leave everything to my kids, and I want so-and-so to be the executor." And he signed that letter and mailed it to the attorney. Between that time and the time the lawyer got around to doing the will, the guy died. And so the question of the family to us was could we use this letter? I mean, here in this letter from him was exactly what he wanted the will to say. So could this letter be treated as his will? And the answer is no. And the reason is because he did not intend for that piece of paper to be a will. You have to actually intend for the document to be a will. This is why you will often see on the very top, it'll say something like, last will and testament, right? What you're doing is you're establishing that piece of paper you intend to be a will. The other place you could see testamentary intent would be, for example, if I just wrote out a piece of paper and I said, I want Bob to get my car. All right, is that a will? No, because it doesn't say that I want Bob to get the car at my death. I mean, do I want him to get it now? Do I want him to get it in the future? So it's not clear. So you're clearly establishing, right off the bat, you're going to want to say, I'm making a will. Put the title across the top, last will and testament, or whatever. But that's to identify that you have testamentary intent. So that's the first thing you've got to have. The second thing you've got to have is not be crazy. Not be mostly crazy. All right? Testamentary capacity. In other words, the mental capacity to make a will. That's the second requirement here. You've got to have the brain power. But the brain power to make a will is very, very low. Over the years, there's been lots of cases on all of this sort of stuff, and basically they have narrowed down and said in order to have the mental capacity to make a will, you've got to have three things. You've got to be able to know who your people are. So, are you married? Do you have kids? Do you know these people? So you got to know who your people are. This is what they call the natural bounty. Who would normally get your stuff, right? So you got to know your people. You have to know the nature of your estate. In other words, if you own a house, you got to know you own a house. Do you have a car? Do you have money in the bank? You don't have to know the dollar figure. I don't know the dollar figure I got in my bank right now. I ate lunch before I came over here, and I hadn't done the math yet, right? But I know I have a bank account, and I know there's money in it. So you got to know who your people are, you got to know what you got, and you've got to be able to hold those two things in your mind long enough to execute the document. So that's the third prong. That's it. Know who your people are, know what stuff you got, and hold all that information in your mind long enough to make out the document. That's it. So, went over to taco place, got me some tacos, and while I was sitting there eating the tacos, one of the tacos started talking to me. And it said, John, this is Mr. Taco, and I have got some bad news. After you get done with your speech, there's a pretty good chance that you're going to fall dead from having eaten this taco. And being the kind of guy that listens when a taco talks, I thought, well, before I do the speech, I probably ought to get my affairs in order. So while I was waiting in my car outside, I got out a piece of paper, and I thought to myself, I said, well, I'm married, I have 4 kids, and so I would want some things to go to my wife, I'd want some things to go to my kids. And I started thinking about, well, what things? And I've got a house, I've got 2 cars, I've got some money in retirement, I've got my business. And I start thinking about all of those things. And ultimately, I write all of that out as to who I want to get what and sign it and all of that. And I'll get into that later. But I've written all of this out now in a will so that if the taco premonition comes true, I'll have all my affairs in order. Now, let's say that I did, in fact, die right after this. Would I have created a valid will? Absolutely. The fact that I thought tacos were talking to me is irrelevant. Did I know who my people were? Yes. Did I know what stuff I had? Yes. Was I able to hold that information in my mind long enough to make out the document? Yes. The fact that I was doing it because I thought tacos were talking to me is irrelevant. This is why it is so hard to undo a will. Yeah, I have lots of folks that are maybe upset. Somebody has died, there is a will, they're unhappy with that will, and they would like to challenge that will in some way, shape, or form. And often they will say, well, Mom had Alzheimer's when she did that will. So? I mean, you could have Alzheimer's and still know who your people are, know what stuff you have, and hold that information in your mind, especially if it's early in the process of the disease. Later in the process of the disease, maybe you don't have all of that. The problem is, if they want to challenge that will, they're going to have to prove that at the moment that thing was signed, that those three things were missing, or at least one of those three things. It's very hard to prove. Now, there was a case just last year in Texas where a will was thrown out because the guy did not know what he was doing. And the evidence in that case was this guy was in his 80s when he died. He had been married for 50 some odd years to the same woman. But toward the end of his life, he was 100% convinced that she was having an affair on him. His 80-something-year-old wheelchair-bound spouse, probably not likely. I mean, I guess it's possible, but based on the evidence, that was unlikely. So the one of the things the court said was, maybe he doesn't really know his people. I mean, he knows who his wife is, but the fact that he's so convinced that she's having an affair when there's absolutely no evidence of that is probably that maybe he doesn't really know his people. In the will that he had done this late will right before he died, and in that will, he said that he wanted this one person to get a piece of property that he had sold 20 years before. And so the court said, on that second prong, he clearly didn't know what he owned, or else he wouldn't be bequeathing a piece of property that he had gotten rid of, 2 decades ago. And so ultimately the court said, yeah, he didn't know his people, he didn't know his stuff, and so they did throw the will out. But it is very hard for most of the time. So all of that to say, you've got to intend to make a will, and you got to have the brain power to do it. And so often that brain power, you'll see that come in the next part of the will. You'll start out with something like, I'm, last will and testament, right? Testamentary intent. And then you'll say, I'm John. I'm married to Lisa. We have 4 kids, right? And now I'm establishing, here's who my people are, right? I live in my house and put the address, and now I know where, I'm right there in the beginning of it. I'm establishing testamentary intent and testamentary capacity. So that's always a good idea. Beyond that, it's not uncommon for, of course, most people, about 70% of people that pass away every year, 60 to 70%, will have died without any estate planning whatsoever. So only 30 to 40% of people will die with a will anyway. Of those people that do die with a will, many of them will change it over time. What you don't want is more than one will floating around out there. Especially if they say different things. A lot of times people will say, well, I've got this will and I left everything to Timmy, but I don't want Timmy to get squat anymore. Now I want everything to go to Sally. We can certainly do a will that leaves everything to Sally, but you don't want that old one that says everything goes to Timmy still floating around. And since you may have done multiple wills over time, then the next thing you're going to want to do is specifically revoke any other wills that are out there. And so this is why you usually right up there at the front, you'll say, hey, this is last will and testament. I, John Ross, hereby revoke any other wills that may be out there, so that this document becomes my last will and testament. There's 2 ways to revoke a will. One of them is by a physical act, right? So tear it apart. You tear it apart, you've revoked the will. But the second way to revoke a prior will is to revoke it in a successive will. So by saying, I revoke any other wills, in that first paragraph, you're revoking all those other wills. So Start out, you're going to revoke all those others. Beyond that, though, we're going to have to give some stuff away. Right? I mean, that's the whole purpose. You're dead, somebody got to get your stuff. Now, when you're giving away stuff, this is where it usually really gets messed up. Because a lot of times people don't necessarily realize the words that they're saying and how they'll ultimately be impacted. So let's just say that I do this will and I say, I leave Timmy my 2014 Chevy Impala. And I have a 2014 Chevy Impala. Now, at my death, the problem is my 2014 Chevy Impala's got 187,000 miles on it. Yes, in 4 years, I have put 187,000 miles on my car. It ain't gonna last much longer. It's doing really good. I've been very happy with this car so far. And I'm gonna see if I can put 300 on it. But after that, it's not gonna be worth much. And so I'll probably get something else. And so let's say that I go and trade in my 2014 Impala for a 2019 Impala and die. Does Timmy get my Impala? Probably not, because it specifically said the 2014. And now it's a 2019. But of course, if you're Timmy, you're going to think that, well, I should have gotten whatever car it is. If you're whoever's getting the rest of my estate, you're saying, no, you were supposed to get the 2014 Impala. And guess what? Now you got you a fight on your hands. If I want little Timmy to get whatever car I have, then I probably should just say, I leave Timmy whatever car I own at the time of my death. If I want him to just get that car, and if that car's not around, then I should say I want him to get this car, and if this car has somehow gone away, then he doesn't get squat. Right? But one way or the other, I want to be very clear about it. So with specific distributions, one, you can run into problems with specificity. There was a lady, this was about a decade ago, and this lady had handwritten out on all these little yellow strips of paper about this big, all of the specific items that she wanted to go to specific people, and she was an artist, and so a lot of it were all of these paintings that she had in her house. And so, it was like, I want the beach scene to go to Timmy. Well, there's like 5 different beach scenes. One with palm trees, one without palm trees. Which beach scene are we even talking about? So again, you got to be somewhat specific there. The other kind of specific bequest you'll often see is a dollar figure. I want my grandkids to each get $5,000 or something like that. Be careful with dollar figures. Let me give you an example. This is, again, all of my stories are actual real stories, by the way. I don't just I do make up some of it, but for the most part, they're all real stories. But this is a real story. So there was a lady here in town. She had 3 kids. She did not have a good relationship with one of them. She had helped him out over the years and really had kind of been a drain on her own personal finances. And so at the time she did her estate planning, she had a net worth of about $200,000. And so what she said in the will was, I want this one son to get $20,000, and I want the rest of my estate divided equally between my other 2 children. Which was fine, seemed fine, right? Before she died, she spent 3 years in a nursing home, private pay, so that at the time of her death, she had about $25,000. What did the will say? $20,000 to the one kid, the rest split 50-50. So the 2 good kids got $2,500 apiece and got to write their no good brother a check for $20,000. They were not happy about this. They understood it. They didn't like it, but they got it. That was real. And they kept saying, but that's not what mom wanted. Well, it doesn't care what cares what mom wants. It's what mom said. What mom said was $20,000 to this one kid. So when you're using dollar figures, be very careful. Generally speaking, I would probably encourage you to use percentages. If she had said, I leave 10% of my estate to one kid, which had she died at that time would have been $20,000. So if she'd have just said, I leave 10% to the one kid and the remaining 90% divided equally between the other two, then her $25,000 would have gotten spent $2,500 to the bad kid, and the other two would have gotten the bigger share as she intended. So you can't just assume. Now, if you're Elon Musk or one of these billionaires and you want to leave a few people $5,000 apiece, well, that's fine. There's no way you're going to spend $1 billion down to $10,000 where that's going to become a problem, right? So, looking at the nature of your estate, that may be okay, doing some actual dollar figures. But you don't want to get into a situation where you have left specific dollar figures and then you don't have enough money to give those specific dollar figures, or that it messes up in this. So be very careful. Typically, if you're going to split stuff up like that, use percentages instead of dollar figures. All right, beyond that, you're going to want something called a residuary clause. This is who gets the rest. And it is possible to die with a will and without a will at the same time. Now that may seem impossible, but it's not impossible. Guy died, he had done a will, he had done it on his own. And in the will, he said, I want my house to go to this person, and I want this other piece of land to go to this person. And he had signed it, and that was, in fact, he had created a valid will that disposed of the house and this other piece of property. But what about the cash? What about the other money, the cars, the personal property? None of that was addressed. So this is what they call partial intestacy. He died with a will as it related to the two pieces of property, and without a will for everything else. So what we ended up having to do was basically two probates for one dead person, right? We've got to probate the will so that we can do that part. And now we have to do an intestate administration, which is a much more involved process, just to dispose of the other assets. You avoid all of that with a residuary clause. And this guy had gone to one of the office supply stores and gotten one of those like peel-off, fill-in-the-blank wills that you can get back in forms in the back of the office place. And it actually, it had, I blank, and he had written his name, and, I leave the following, and he had written, property here, property there. And then the next paragraph said, I leave the rest, residue, and remainder of my estate to blank, and he had crossed that out. And I'm just thinking he probably just didn't understand what it was asking. But this is the residuary clause. This is everything else I got, here's who I want it to go to. So often you might say, yes, I leave this person this piece of property, I leave $10,000 to little Timmy, and then I leave the rest of my estate, whatever kind, to these people, or this person, or whatever. And at that point, now that you've said the rest of, that's everything, and so there is no partial intestacy. Now you've died, your will covers the whole deal. So give away some stuff, appoint, you appoint you do the residuary clause. Now, one other thing on the residuary clause, all of these people that you have said to get stuff, they may be dead before you're dead. It's possible. And it's even possible that everybody that you've listed is deceased. We have clients rolling up into their hundreds. We even have, so far, we have had 2 superseptenarians. Anybody know what that is? That's somebody 110 or better. Yeah. You know what happens when you get to be 110? Everybody you know is old. Your kids are old. Your grandkids are old. And in fact, not only are they old, most of them are deceased. And so, if you said, well, I wanted my son Timmy to get this, and you're 110, there's a pretty good chance Timmy ain't around. When you talk about getting old and dying all day long, if you don't joke about it, you will go mad. So, don't find anything I say offensive. That's how I keep my head on straight. Anyway. But you take me, it's me and my wife, we got our 4 kids, and if the 4 of us were to go on vacation and we decided we would like to take a Malaysian Airlines flight across the South China Sea, which if you remember, they don't have a good luck with that here recently. If the plane goes down and and here I've got this will, it says I leave everything to my wife's not around, leave everything to the 4 kids, and if any of the 4 kids have died, their share goes to their kids, and I've listed all of it, the plane went down, me, wife, 4 kids, no grandkids, we're dead, all of it gone. Did somebody say the state gets it? Not quite. Although I'll talk about that in a second. That's actually interesting. Generally speaking, in both Texas and Arkansas, your assets do not revert to your estate. In this case, if I didn't have anything else, the will would now be invalid because there's no beneficiaries. I would be treated as having died without a will now because there's no beneficiaries. And the way both Texas and Arkansas law reads is, if you die without a will and you've got no descendants and no spouse, then you're going to go up to the parents, see if they're alive. If they're not alive, you go out to the brothers and sisters or their descendants. And if you still haven't found a warm body, then you're going to go up to my grandparents, to their brothers and sisters, and down to their kids and their kids. And you keep going up the tree and down the branches until you find a pulse. And theoretically, you do that until you find a pulse, and that it would not then revert to the state. But to avoid this, one thing you might want to do is include a remote contingent beneficiary. Many of y'all know I'm the president of the Alzheimer's Alliance, so I've got a pretty big heart for that. Lisa Scholmeyer next year will be the president of Opportunities, Inc. Here in town. And so those are our 2 little pet charities. And so if you look at our planning, everything goes to each other, goes to the kids. If kids aren't around, their share goes to their kids. But if we're both dead, the kids are all dead, and we have no descendants, then our estate splits 50-50 between Alzheimer's and Opportunities, right? Just that plane crash clause is what I like to call it. Now, to your point about going to the state, there actually was a recent case on this in New York, and this is really kind of just as an aside, but there was a gentleman, he was a Holocaust survivor. So he had come from Poland and immigrated to the United States, moved in with the Polish Jewish community in New York at the time. This Polish community, Polish Jews, had started buying up a lot of property. And this gentleman from the late 40s on had actually become very, very wealthy. He had a wife through a good portion of this time, but the more his wealth got, the more he liked to party. And his partying lifestyle and his wife didn't mix all that much, so she dumped him, and he spent the remainder of his years basically partying like a rock star. There's some great pictures of this guy, and he's, he's just like that classic New York, overweight, the big sunglasses, wearing the little swimsuit by the pool. Oh, it's just as tacky as it can be. Just that egregious Yankee wealth is awesome. Anyway, he died, and despite having what they estimated was about $100 million net worth at the time of his death, had no estate planning. He died intestate. He and his wife never had any kids. He was not married to her at the time of his death, so she's not an heir. And so it came to this whole family tree thing, right? Go up the tree, down the branches, except that Holocaust survivor. They can't find any living relatives of his. And since so many of the records were destroyed in the concentration camps and all of that, so in his case, they did about 2 years worth of research, even going all the way to Israel to try to find records within the Jewish communities there, going back into Poland and looking, and ultimately they have come up with zip, New York is getting his estate. So it can happen, but it's pretty rare. All right, so you've said you're going to make your last will and testament. You've listed who your people are. On that note, be very careful of who your people are. You may think you know who your people are, but are you sure? There's a couple of laws here that can mess you up. First of all, you can leave your stuff to anybody you want to, and you can leave anybody out that you want to, right? So if you say, well, I'm going to leave everything to my 3 kids, that's fine. If you say, I'm going to leave everything to 2 kids and not the 3rd one, that's fine. But what you don't want to do is unintentionally omit somebody, right? If I have 4 kids, but I only want 3 of them to get something, I need to be a little bit more careful here. There's a law called the pretermitted child. And what this is intended to do is, let's say that I did a will when I had 3 kids. And so in the will, I say I leave everything to the 3 kids. Later, I have a 4th kid, but I never go back and change the will. And I die. So my will says I leave everything to my 3 kids, even though at my death I had 4. The law presumes that since I did not mention that 4th child, that I made a mistake. And had I not made a mistake, that child would have been included, in which case they get to come back in. So what if I just didn't want the 4th child, though, to get anything? In that case, I need to be very specific. To avoid this pretermitted child claim, I've got to be able to say, I've got 4 kids, 1, 2, 3, 4, but I don't like number 4. I don't want number 4 to get anything. So I'm not making any provisions for number 4. Now, I've clearly identified them, so I clearly did not make a mistake. I'm just disinheriting them. You can do that, that's fine. You just got to be clear about it. And this baloney about you got to give them $1 is one of the most pervasive myths out there. Well, you have to give them $1. Don't give them $1. Guess what? If you say, I don't want little Timmy to get anything, but I've heard I got to give him $1. And so you give little Timmy $1, well, yes, one, he's entitled to the $1. He's also entitled to notice, to participate in all the court proceedings, an accounting of your estate. And basically, you've just opened the door for little Timmy to come in and wreak havoc in response to you cutting him out for everything but $1. That $1 is going to cost so much money. On the other hand, if you say, I ain't leaving little Timmy nothing, then Timmy doesn't have to be a part of the estate. He doesn't have to have notice. He cannot participate in the hearings and all of that sort of stuff. So don't give him $1. Cut him out completely. So 1 is the pretermitted child. And then the other is what's called adoption by estoppel. Ever heard of that? Probably not. Most people haven't. Well, you know what an adoption is, right? An adoption is where you go through the court process of taking somebody that's not your child and making them so that legally they are your child. Okay? Think of it this way. You've heard of common law marriage, right? Where even though you never went down and got you a marriage license, you've held yourself out as husband and wife. You've lived together as husband and wife. You might even share the same name as husband and wife, but you never actually got officially married. And so the law says that even though you never got officially married, you're still married. Common law. So that's what they call a common law marriage. Let's say that I get married. Here, we'll use the example. How about the Brady bunch? Right? He's got 3 boys, she's got 3 girls. They all raised them together. Right? So, husband and wife Brady, they don't treat any of the 6 kids any different than one another. They raise them together as if they were all theirs. Now, Mike Brady dies. Now, his legal children, his biological children, are the 3 boys, which means her 3 kids really should not have any part of his estate. But what they could say is, well, even though there was never a legal adoption, he treated us as if we were his own children. And so we should be treated like adopted children, even though there was no adoption. So just like you can be common law married, you can have what is basically a common law adopted child. The legal term for this is adoption by estoppel. And all that really means is that you're prohibited from denying that it's your child because you've treated them like your child. So if you have a blended family situation, even though somebody's not necessarily your kids, not a bad idea to say, I have 2 kids, I have 2 stepkids, I'm leaving everything to my 2 kids, and I'm not providing anything for the stepkids, because that prevents both the adoption by estoppel claim and the pretermitted child claim. So even though they're not an heir, you might want to throw them in there anyway. All right, so like I said, you've listed out the will, you're going to make the will, you've got testamentary capacity, testamentary intent, you're revoking any prior wills, list out who your family is, who you want to get stuff, who you don't want to get stuff, and then you've said what stuff you're going to give them. Somebody has got to be in charge of all of this. That's your executor. Or if you're appointing a female, it's an executrix. Or in this modern world, I don't know what new names we'll come up with. Given the fact that we were filling out college applications this time a year ago, and the college application for the Massachusetts Institute of Technology, MIT, on the first page of the application had name and then gender and had 7 options. Seriously. 7 options. But anyway, traditionally speaking, you have either an executor or an executrix, although mislabeling those does not invalidate the will. So if I say executor and I'm referring to a female, or executrix and I'm referring to a male, it doesn't matter. It doesn't invalidate anything. So the executor is the person or entity that you want to be in charge of everything. That can be a person, or it could be an institution, like Regions Bank or somebody like that. So you can appoint a person, you can appoint an institution. If you're going to appoint a person, they do have to be qualified to serve. So even though you're appointing somebody, for example, let's say that I really wanted Charles Manson to handle my estate. Seemed like an honorable dude, handles business, good with money. And so I think, no, they're not, he's disqualified. Being a felon would prevent him from being my executor. Even though I wanted him to be my executor. I don't get a choice in that. He is prohibited from acting in that capacity. So you can't just go and appoint felons and things like that. Also, if somebody owes me money, they're generally prohibited. And so that's considered a conflict of interest. If they're in charge of all my stuff, but they also owe me money, then it seems like they might say, well, I don't think he owes me money anymore. So anyway, but you want to pick somebody. Now, what you'll often see is you'll see I appoint so-and-so as the executor, but then you'll see a bunch of junk after this. And here's why. So the first thing is, you appoint the executor, and then when that will is probated, the court is going to appoint that executor. But just because the court has appointed that executor, everything that executor does as it relates to your estate requires additional approval by the judge. So that executor wants to pay some bills, go ask the judge for permission. Wants to sell your car and turn that into cash, go ask the judge for permission. Wants to sell the house, go ask the judge for permission. Well, that's a pain. In fact, if you're talking about having to go back and forth and file new stuff all the time back in that court system, not only is that a pain, but it's going to get expensive because it's going to require your lawyer every time to do that, right? So often what you'll see is you'll see them say, I appoint little Timmy as the independent executor. That phrase, that word right there, independent, means that you're saying that once that executor is appointed by the court, you trust them enough to not go back to the judge and they can just handle business. They need to sell the car, sell it. They need to buy some stuff, buy it. They need to pay some bills, pay the bills, whatever. All they've got to do now is just get appointed, file an inventory, and publish the little notice in the newspaper. But other than that, they don't have to go back to court for all of this other junk. So that's why you'll often see independent executor. The other thing is this executor is going to be in charge of your stuff. And really, there's nothing stopping them from going and collecting all your money and fleeing the country. Right? They have the power to collect all your stuff, and although they're supposed to give it all to the beneficiaries, there's nothing stopping them from collecting it all up and running away. So what the next thing the court's going to do after they appoint the executor is they're going to say, well, if the value of this estate is $500,000, then you as the executor need to go buy an insurance policy that says that if you mismanage this $500,000 worth of assets and you run away with it or you squander it or do whatever, then this insurance money will come into the estate to reimburse the beneficiaries. It's what's called a probate bond. Now, $500,000 probate bond going to cost probably around $4,000 or $5,000 just to get that insurance policy. About 10%, depending on where you get it from. Now, if you're appointing your most trusted pal in the whole world, that may be excessive. I don't need them to go. I trust them to do it right. They don't need that insurance. In which case, now what you might say is I appoint Timmy to be the independent executor and to serve without bond. And now I'm telling the judge, hey judge, this guy, he's a good guy. He doesn't need your permission to do everything, and y'all don't have to fool around with that whole probate bond business because I'll trust him to do what's right. All right? So that's why you'll often see somebody's appointed as the executor, but independent executor, and then it'll also say to serve without bond. So once you're appointing that executor, you've got to say, do you want the executor to have to go back to court or not? And do you want them to post that bond or not? And then the last thing is you're going to have to sign it. It's got to be signed. Now, there's two ways you could have done everything that I just talked about in order to make it valid. You could have put the whole thing in your own handwriting. handwritten, write everything that I just talked about out and sign it. If you did that, you have created what's called a holographic will. Perfectly valid. Entirely in your handwriting and signed. And people will say, well, don't I need to go get that notarized? If you get it notarized, is it entirely in your handwriting? No. Did you just invalidate your holographic will by getting it notarized? Yep. Entirely in your own handwriting. Don't have your grandkid handwrite it for you and you sign it. That's not entirely in your own handwriting. So, you do it entirely in your own handwriting and sign it. That is a valid will. Now, notice I say valid but not good, because even though it is a valid will, in order to probate that will, one of the first things that's going to happen is we're going to have people come and testify to your handwriting. So we've got to find at least 2 people who are familiar enough that they're willing to swear it on oath in the courthouse and the whole deal, that they know your handwriting, that they've reviewed this document, and that they are 100% convinced that that's your handwriting. And if you have even the slightest possibility that somebody's unhappy about your will, I guarantee they're going to have 2 people that say that's not your handwriting. So the second thing, the other way to do it, if you don't do it entirely in your own handwriting, so if it's typed or somebody else writes it or something like that, then it has to be signed by you in the presence of 2 witnesses, and those 2 witnesses have to sign in your presence. So you sign it with the 2 witnesses watching you, the 2 witnesses sign while you watch them, everybody signs watching each other. All right? The 2 witnesses cannot be related to you. They cannot be beneficiaries of the estate. They need to be independent witnesses. And if you live on the Arkansas side, your witnesses have to be at least 18 years old. If you live on the Texas side, your witnesses have to be 14 or older. I have no idea why. That's just what the rule is. So you get it witnessed, signed, you get it witnessed by the 2 witnesses. Notice I still didn't say notarized. There's no requirement that a will be notarized to create a valid will. Now, you might say, okay, but John, every will I've ever seen was notarized. Well, here's why. So let's say I'm going to do this will, and I'm going to get these 2 fine people here to act as my witnesses. Okay? Now, I sign it in their presence, they sign it in my presence. I've created the valid will. Y'all, I live in Texas, so I assume y'all are 14 or better. So I've created this valid will. Now, I'm 45, and so with a little luck, I'll make it another 40 years. So 40 years from now, I die. And now we've got to go probate this will. And when we probate this will, in order to probate this will, I'm going to need you 2 to show up at that hearing. Because I need you 2 to say that you were there and you watched me sign it 40 years from today. Y'all cool with that? Yeah, maybe not. So maybe, just to avoid that little problem, maybe what I ought to do is I ought to slap another piece of paper on the back of this will. And on the back of this will is going to be a sworn statement, an affidavit. An affidavit that says, I, John Ross, swear, and these 2 people swear that I signed this and that I was of sound mind and over the age of 18, and that they signed it in my presence, and that they were in my presence when I signed it, and they, on today's date, are over the age of 14. And we all swear to this on this affidavit, which is then notarized. What we now have is a sworn statement. And so 40 years from now, when we go to probate that will, I don't need y'all to show up anymore. Instead, we can just use that affidavit that says we were all there, we all signed in each other's presence. So that's what's called a self-proving affidavit. It proves the will was executed appropriately at the time, so you're not having to drag in witnesses later on. All right? So if we've done all of that, we have created a valid will, and we have done that in just about an hour. Any questions about any of this? I can talk about this stuff forever, but I just wanted to hit the highlights. Yes, sir?
Mr. Ross, are all wills go through probate?
So your question is, and I figured somebody would ask that. I was hoping I'd get wrapped up a little sooner just so I'd have a little more time. But your question is, do all wills have to go through probate? There's two questions here that sound alike that are completely different. One question is, must a will be probated in order to be valid? The second question is there a necessity to probate the will? Those sound like the same question. They are two different questions. Let's say I'm a hobo, okay? The only thing I own in the whole world is a half-eaten fried bologna sandwich. That's it. I have a will that says I leave everything I have in the whole world to you. Now, that will is only valid if it has been presented to a court and stamped with that judge's seal of approval as part of that probate process. And if you do not do that within 4 years from the date of my death, 5 years in Arkansas, 4 years in Texas, then you will never be able to probate that will. You got 4 years from the date of my death to probate that will, and if you don't do it, you will not get my fried bologna sandwich. Now the question is, it's going to cost you $300 just in court costs to file the will for probate. And there is no fried bologna sandwich on the planet worth $300. I mean, we're talking 2 pieces of white bread, some mayonnaise, and a piece of bologna with the little slits cut in it. That ain't worth $300. So, must you probate the will in order for it to be valid? Yes. Is there a necessity to probate the will? No. Because you wouldn't do it just for the sandwich. That makes sense? And the reason I say that is that's an extreme example, but what if I had life insurance that named you as the beneficiary and a fried bologna sandwich? Well, you get the life insurance because you're the named beneficiary. You didn't have to probate the will for that. So if I have named beneficiaries on my IRAs, my bank accounts, my life insurance, that's going to go automatically. If I've done a ladybird deed on my house, that's going to go automatically. If I've set up a trust and all my assets are in the trust, that's going to go automatically. So there can be many situations where there's no need to probate the will. Doesn't change whether or not the will has to be probated in order to be valid. It does. It's just that in many cases, you don't have to. Any other questions?
What is the ladybird will?
What's the ladybird deed? A ladybird deed is a deed that says something like, this is my house, I can do with it whatever I want, I can sell it, keep all the money, it's my house. When I die, you get my house. What that does is I've basically just named a beneficiary on a house. It's my house, I can do with it whatever I want as long as I'm alive. I die, it's your house. Automatically. It did not go through this probate process. It passed automatically. One of the benefits of a ladybird deed is that would also keep it away from a nursing home had I been on Medicaid prior to my death. So that's one of the main reasons we use ladybird deeds. But it is also a simple way to avoid the necessity of probate with a home or other real estate. Other questions? Lots of them. Yes, ma'am.
We're talking about children and mentioning all 4, not just 3. But if you're talking about a niece who's going to be the beneficiary, but she's got a sibling brother, the rule will still apply. You have him mentioned.
Yeah, so your question is, I was talking about disinheriting children and things like that. Maybe you're just going to leave everything to a niece, but that niece has got a brother too. The main thing here is you look at who would ordinarily inherit from you. So if you died without any planning and you didn't have any kids, then it's very possible that your estate would go to your brothers and sisters, and if they're deceased, to your nieces and nephews. They would be the natural object of your bounty, in which case, probably not a bad idea to disinherit the nephew specifically and leave everything to just the niece. Now, if you've got 2 kids and you're leaving everything to your 2 kids, but you just want this $5,000 to go to your niece, you probably don't need to specifically disinherit the nephew in that situation because they're not a natural heir. But if they're potentially a natural heir, not a bad idea. And in fact, a lot of times you can say something like, I'm leaving everything to my niece. Anybody else who's not mentioned is disinherited. And that pretty much covers everybody at that point. All right, we'll take one more. Yes, ma'am. Can I touch on trust? I tell you what, I figure we'll probably do a whole nother one. I can sit here and talk about trust for longer than I can talk about this. Generally speaking, a trust is almost like a will alternative. A will goes into effect when you die. So you die through this probate process, the will goes into effect. A trust goes into effect now, and since it goes into effect now, it doesn't have to go through the probate process at your death. Very simply, that's a kind of a will versus trust. But there's a million things you can do with trusts over and above that. All right. Now, you mentioned that when she asked about ladybird deeds are Texas specific. There are ways to do that on the Arkansas side as well. There's what are called beneficiary deeds. And there's also right of survivorship deeds. So there's a couple of different ways to do it on the Arkansas side as well. Yes, ma'am? What about pets? You live in Texas? Awesome. Texas is one of the few states in the United States that will allow you to create a trust for the benefit of your pets. Normally, if you want to leave something to somebody, it has to be a somebody. Or it has to be an entity, like a charity. What I can't do is I can't leave property to property. Right? So I can't do up a will that says, I leave my couch, my dining room table. Right? I can't leave property to property. Legally speaking, despite what people feel emotionally, legally speaking, pets are property. So if I were to say, I leave $50,000 to my dog, that's the same as me saying I leave $50,000 to my couch. It doesn't work. But in Texas, they have come up with a way. And so there are ways in Texas that you can establish a trust for the benefit of your dogs or cats or alpaca or whatever it is, so that money can be used for their care and maintenance. You can line out what kind of treatment you want for them and where you want them cared for. And then at the animal's death, what happens to any residual funds and stuff like that. So you can do that. Yes, it's a bit more complicated when you get into that. And I have had a will contest over a $50,000 bequest to a Cocker Spaniel. It was a very expensive case. It cost everybody involved a bunch of money, all because basically the lady said, I leave $50,000 to Sophie. And Sophie was a Cocker Spaniel. And we had a problem. And this was before the laws changed. But anyway, yes, you can do it. One last question. Yes, ma'am, in the back. So your question is, what do you charge to make a will? That is going to vary wildly. For example, I have had folks come in and they have a relatively modest estate. Maybe they got a house and some money in the bank. And often for those, we don't even do a will. I suggest doing something like a ladybird deed on the house and then going over to see your regions person or your bank person and naming a beneficiary on the bank account. In which case, you die, house goes outside of probate, bank account goes outside of probate. You didn't need a will. In which case, you didn't need to spend any money on one. And if in that case, if it just made you feel better to have one, Then write you out a little something that says, if I got anything else outside of that house and bank account, then I want it all to go to little Timmy. Put it in your handwriting, sign it, and you just made you a holographic will. You're not going to need it anyway. But if it makes you feel better having it, great. On the other hand, I've got clients over here that own a 1,000-employee business. They got property in 5 different states. They got a taxable estate so that the estate tax is going to hit them. Their will is 75 pages long. Time we get said and done with all of it. That costs money. So it can literally go from a couple of $100 on one end to thousands on the other, depending on the nature of your estate. Whatever weird little complications you may have are going to be various for everybody in the room. You might have a simple estate, but you've got a disabled child. That's a big complication, You may have a relatively big estate, but it's the Brady Bunch, and everybody's happy, and it's all wonderful. Well, you can probably get away with something simple. So it all varies. All right, I'll tell you what, I'll hang around for a few in case anybody else has any questions, but otherwise I'm going to let y'all go since we're about 10 minutes over. We try to get y'all out here on time. So I appreciate y'all letting me run my mouth.